evening and welcome everyone to today's panel discussion on the new workplace rulebook about POSH, gig economy, and employee rights. I'm just going to wait for 2 minutes so that I can allow people to join into our live session. And once we have a fair amount of people, we can start the discussion. All right. So till then, I'll just introduce the topic a little bit, what we're going to talk about today. So the idea of a workplace has changed dramatically in the last few years. Offices are no longer limited to four walls. Employees are no longer always on payroll, and technology is now deeply embedded in how we work and how work is assigned, monitored, or even how people are terminated. Yet many of our labor and employment laws were drafted in a very different era. Today, we're navigating complex questions around POSH compliance in virtual spaces, the legal status and protections of gig and platform workers, data privacy at work, and whether employees truly have the effective remedies when disputes arise. So today's discussion aims to go beyond theory. We want to understand what the law says, where it falls short, and how courts and companies are responding, and what needs to change as we move into 2026 and beyond. We are joined by legal practitioners who deal with these issues, not just in textbooks, but in real workplaces and real manage real disputes as well. So I would like to introduce our panelists to you. First, we have Advocate Siddharth Das, who is a partner at Aruma Associates, a leading legal firm in Kolkata, and Vera Lex, a leading full-service legal firm in New Delhi. His practice spans intellectual property arbitration and international commercial arbitration in high courts and Supreme Court. We also have Advocate Deepika. She's a partner at Vigil Jurist and has over 12 years of experience specializing in real estate, insolvency, corporate advisory, and commercial dispute resolution. We'll also be joined by Advocate Sushti, who is a legal practitioner from Ahmedabad with over 20 years of courtroom experience across civil, criminal, commercial, and corporate litigation, appearing up to the Supreme Court of India. So a very warm welcome to our panelists for today. I would like to open today's discussion by the question of how has the definition of employee changed in 2026 with the rise of gig and hybrid work?
Okay,
Anyone, if
formally,
you can take that up.
yeah, formally, the statutes that we have, as per my consideration, I mean, they can differ if they want. Still in on the classic employee and employer model, but this code on social security now separates two things. One is the gig and the platform, because but the recent decision of that Ola case, that actually helps in setting the difference between gig and platform workers. That actually sets the precedent, in fact. So mainly for social security purposes. But courts are, however, increasingly, they are increasingly using a control and dependence test rather than just label them in the contract. The Karnataka High Court decision, as I was saying in the Ola's decision, treats drivers as employees also for POSH, despite their independent contractor contacts. So in 2026, the real shift is less deference to contractual levels, more focus on how the work is actually structured in the digital and the hybrid ecosystems, as per me. So this is how the employee definition, as per me, has changed.
Okay.
And I think Deepika ma'am or maybe Shruti ma'am, they might be able to lead more and say something more on this.
So yeah, earlier it used to be court were looking into only appointment letters or a salary structure. Now mainly they are looking at whether there's a control over work or economic dependence. So the definition has has widened, because now it's not limited to physical workplace. There we
Right.
have to include, so that, but the POSH Act defines employee or a workplace in a very wider manner. So it includes everything. So Yes, but the framework has to be taken in place, and courts are really working. It's evolving, but the framework is still not in a place.
All right. And then what are your thoughts about Indian labor laws keeping in pace with, platform-based and remote workplaces?
See, this is what I exactly was referring to the case of Karnataka High Court. See, India no doubt has moved faster on recognition and social security through these gigs and these platform worker definitions, and maybe some proposed schemes. Then on core employment rights like minimum wages, minimum hours, the protection from unfair deactivation. So, but if you see, uh, the much of our enforcement machinery still assumes a physical workplace that normally creates a gap when dealing with app-based allocations. It also involves a remote oversight and cross-border teams. So, but this is quite visible in that particular case. I think it was. Correct me if I'm wrong, ma'am. It's MSX versus ANI. That is Ola, I think.
Ola,
ANI Technologies,
yes.
where the court, I think, effectively had to repurpose an older welfare, that is the POSH, to fit a highly modern, platform relationship. So the Indian levelers normally have to come up to the mark to address these issues.
So POSH Act requires to be amended. So India has introduced a labor codes which for the first time they recognize gig and platform workers, acknowledge non-traditional work models. However, the implementation is really slow. Many protection exists, but it's only on the paper, like remote work reality or data protection, data privacy, digital harassments are not fully addressed. So it's require amendment in our POSH Act.
Right,
Implementation is the problem. So
right.
law is trying to catch up, but the workplaces are evolving faster than the regulations. So we need to be, court has to be this
Yeah,
or
so touching upon POSH itself, right? Like when we talk about the act, um, is it effective, or is it vast enough to include remote and hybrid workplaces, or even when we talk about gig-based work environments?
So let me put this way. So when we say POSH Act, conceptually it's really strong because it's defined workplace very broadly.
Hmm.
It covers conduct connected to work, no, and it's not just physical offices. So you can interpret it the way it requires. But in practice, effectiveness will ultimately depend upon whether companies update their POSH policies, whether ICEs, as internal committees are, whether they are trained to handle digital harassment, whether platforms accept this responsibility. So law is effective in theory, but again I said implementation is really uneven. I mean, it's ultimately organization who have to, draft their policy to mesh with the current scenario.
Right.
Okay, just carrying that forward,
Hmm.
I do agree with that. You see, courts and tribunals have treated obscene or harassing messages sent on digital platforms in the context of work as workplace misconduct, reinforcing that location and time are not decisive at all. And as man said, effectiveness on the ground depends on whether organizations update their post policies, the internal committee training, and also I'll add to that evidence handling to deal with screenshots, chat logs, and non-payroll workers.
Hmm.
Something that was criticized harshly by the Karnataka High Court in that Posh case, in that Ola case.
So courts are trying to fill up the gap, but ultimately organization has to look into it. They are team. The committee should be digitally trained. They should know how to
Right.
handle. Problem is most of the organization don't have the ICs or internal committees, or if they have, there is a they are not properly trained, and with this
Right.
they need to be trained properly.
Right, right. I mean, I feel like a lot of companies still struggle with uh, dealing with the traditional way of the workplaces and dealing with posh cases there. So, I mean, talking about digital workplaces or virtual workplaces is another completely
Way to go.
different. Yeah,
Even we have also faced I do not know about man, but I have also faced lot of these things, like forget Ola or Uber or something of that stuff. If you talk of Zomato, it's a service delivery app also.
Yeah.
Zomato, sometimes the driver goes off,
Mm.
and when you complain to the internal committee, like when there is a complaint, you raise a complaint or something, they say we'll look into it. But actually, that is happening or not, that's still not clear.
Correct. Yeah.
So the the organization updating the post policies is much more important than courts implementing that, because as you know, our courts are riddled down with so many cases, and another new case will
Already
take.
overburdened.
Right.
So
So again, when we talk about gig workers, since we were talking about Zomato and these drivers who are registered, like, so it's an aggregator, right? So we are their customers on the platform, and the driver also can register themselves on the platform. So how do you deal with that complexity? Are these then gig workers to be treated as employees, or are they to be treated as an independent party, only utilizing that platform?
So
uh, yeah, you go ahead, then I'll tell.
So when it comes to gig worker, whether they are permanent employee or not, or whether they are on contract basis, is ultimately depend upon their contractual terms. But when it comes to filing a complaint, whether they are eligible or not, so POSH does not restrict protection to only permanent employee. If you read the employee definition, it covers workers. It's workers engaged through agents in, so it's kind of any woman working in connection with the work, so they need
Yeah.
not be permanent employee. The provided the platform controls the work, like if we talk about Ola or Zomato, whether they control the work, we need to read that policy whether they are controlling the work of the contractor or employee or a gig worker. The harassment, so when you want to file a complaint, we need to see that harassment or any offenses occurs during that working hours or during the work, or there is a clear work relationship between that, then the gig worker can also invoke POSH.
Hmm.
So they need not be a permanent employee, and courts
Yeah.
have supported their view. We have seen the Ola case.
Yeah. Yeah.
Okay, see, as far as these codes are concerned, I think they place this gig and platform workers outside the typical employer and employee relationship.
Hmm.
And most platform contacts label them as independent contractors. But you see the cases like this Ola case, they show like how courts are looking through the contract and is asking who sets the fares. The driver does not. Okay. Who sets the controls access to customers? Who designs the rating systems? And who can suspend or deactivate that particular worker? That independent worker also. In these sectors like ride hailing and delivery, that level of control and economic dependence, if you talk of, makes many gig workers functionally similar to employees.
Correct.
But
So
they have weaker rights. If you look at that point of view, they have weaker rights and wages. Yeah, I mean, on ionization and job security. Hence, this dependent contractor debate is always on.
Yeah.
so mainly
And
we have to say that the platform has a control over that
Yeah.
employee
yeah,
worker.
like we were talking about even harassment, but I think in terms of other benefits also, I think recently some court said that these gig workers will also be eligible for EPF, if I'm not mistaken. But before they weren't, and there are a lot of benefits like this, or a lot of rights that full-time employees enjoy at workplaces, or not just gig workers, but there are a lot of people who work as freelancers, who work on a contractual basis with companies part time. So do you think that there needs to be more laws protecting these nature of employees, or there needs to be more definition of what rights or what protection they can have when it comes to being in a part time or a temporary sort of a employment?
So
In this,
they already have statutory recognition. These gig
Right.
workers, they have access to certain social security schemes and a growing ability to invoke POSH against platforms. and wherever applicable, the clients also. Then there are state level initiatives, for example, proposed gig and platform worker welfare legislations. They aim to create databases, welfare boards, and minimum welfare standards for such workers.
Mm.
However, I feel they still lack uniform national guarantees on minimum pay, notice before deactivation, and collective bargaining. Most protection in these areas must be negotiated contractually. I think contractually, or maybe through sector specific litigation. Um, I think so. That's my take on the legal rights you are talking of these gig workers.
So they are not as such they are not under the definition of employee in
Yeah.
POSH, but it's widely definition is really wide, so even gig worker can take a protection under that act. But they are recognized under, as sir said, social security code. They are recognized and they have access to welfare scheme. But what they don't have as on today, it's their job security, or that guaranteed minimum wages,
Yeah.
or their collective bargaining rights or union rights. So it's a partial, so law is required to be amended considering today's scenario, and they should be included in a definition under the act to seek
Yeah.
the such, protection. Yeah,
Yeah, because I feel like the nature of how employment is traditionally is in itself changing.
it has
Uh,
totally.
yeah. So not just, not just these employees on platforms, but even when we see other organizations, or even in our organization, for an example, we hire a lot of freelancers, we hire a lot of people who are contractually with us, not there permanently, and they obviously are not on our payroll, so they don't enjoy the same rights as full-time employees might. But in with both of you, I would like to ask this question, is that, I mean, obviously you were saying that the implementation is one thing. What changes do you see, or do you would like to see majorly, when it comes to our labor ecosystem, on a judicial front?
Sorry, should I or
Yeah, you can go ahead. Let me
so,
just
yeah. So
contemplate on that. Yeah.
what I feel is most urgent legal reform needed in India is a clear and enforceable framework for a gig and platform workers, which is not there today. I mean, court may pass any verdict in one of the cases, and that will be a different scenario, but it's not there in a statute. While gig workers are recognized under social security laws, their right, their protection, and dispute resolution mechanism still remain unclear.
Hmm.
So it's like a balanced framework that provide minimum protection, defines accountability, and allows flexibility. It is a need of it's an
Yeah.
essential thing to do. So without such clarity, both workers and platform operate in a such an uncertainty, and that leads to a dispute and a litigation. So clear framework is required to be in a place, especially for gig workers.
See, if you see the special platform that ma'am mentioned, um, I think that should be because India already has the legislative path is so far is a middle course. That's a special recognition and social security for gig and platform workers without full employee status. That's what where it stands now. While our courts selectively extend employee-like protection for specific laws such as POSH, so the likely trajectory, in my opinion, is incremental. More sector-specific protections, presumptions of employment, high control arrangements, and maybe state-level gig laws rather than an overnight nationwide reclassification.
Right.
So that would actually help them, give them a view of like, okay, they are also employees.
Correct, correct. And what you're saying is right. So, like, gig workers, yes, we are clubbing them, but like you said correctly, sector wise, also there are a lot of complexities which come into play. Like when we talk about gig workers working on platforms like Zomato or Ola, their nature of work is completely different. But when we talk about corporates, and we see people who work there as freelancers, their nature of work is very different, and how they deal with organizations. So that complexity also plays in, and I think that will also be have to evolve in the future, where, like you said, we'll have sector wise laws in that sense.
So if you talk about that sector wise, what I would suggest, like,
Yeah,
employee is not defined sector wise.
yeah.
Employee is employee. So again, here also, if gig workers are defined,
Hmm.
it will be a general term or it will be broader term, which will include, and then everybody will have to implement the way it relates to
As
that
per them,
organization.
yeah. Okay.
So sector wise, obviously, I mean, I agree to some extent, but it won't be physically possible. But
Yeah,
then, unless, I mean, it has been properly inclusive definition is there in statute, then implementation will smoothly go.
Now, what I meant to say is sector specific protections,
hmm.
because as we are discussing, like every sector, like as they said, Zomato and Ola or Uber or and corporate gig workers, so their work is entirely different. So what I was hinting at, sector specific protections, and maybe state level gig laws, because even today also you go to various um, cities in India, you will find people prefer a local rather than outside. Even who the person outside might be even more intelligent or maybe more accomplished, but still then that's why I thought like maybe a state level gig law for that purpose would always suffice. Maybe a rule, a kind of a rule book, not exactly a act for that purpose, but maybe like a rule book.
Yeah, that may help. Yeah, because
Right.
different state has a different way of,
Yes,
different
yes,
culture, different way of working.
yes.
Yeah, so state wise, though, like for rent control, we have Maharashtra, we have Gujarat, so different because things are different in different states.
Yeah.
But then,
Like I think even shop acts, if I'm not wrong, is something that is state wise, and that also defines some employee rights under that, if I'm not mistaken.
shop and establishment is, I think, central. Like, I need to check.
Okay. And then I might be
It's
maybe
a
wrong.
central act.
Okay. So since we were touching on laws, central laws, or state laws, we also have the introduction of the new labor codes which have come into place, which, to my knowledge, basically consolidate the existing labor laws which are there. But if you could help us kind of understand if there is if anything changes for employers or employees with these new labor codes, or does it stay the same? And what are your thoughts on the new labor codes?
So, mainly the definition of employee hasn't changed.
Right.
So, ultimately, it's about who is employee and
Mhm.
workplace. So, that has not been changed yet. So, ultimately, it's the organization who has to deal with it. They have to have their guidelines. Mainly, the foundation is here internal committees. They should be trained properly. They should be tech savvy or digitally equipped to handle the scenario. Like, nowadays, harassment is not on an email only. It's WhatsApp or social media, or there are screenshots which are shared. So they should know how to handle it. So for me, what I feel and I strongly feel is all the organization should have a strict standard policy to be followed. The team should be strict. The POSH Act is there in a place, but still it's not been implemented. Like, organization having more than 10 employees should have committee in a place, but I don't see, I mean, I feel majority organization don't follow this and they don't have a committee unless there is a harassment case, and then urgently they will form a committee and then they will resolve, and the committee will be such who don't know anything, or I mean they have hardly any experience. So one of the persons should be external member, and that member may not be in place. So it's not being taken very seriously unless there is an incident and then they rush up to form a committee. That's what I have experienced.
Right.
See, the on paper employees are better placed. The labor codes consolidate rights. The POSH has a strong body of case laws, and privacy and data protections are also emerging as new protective doctrines. But then, if you see, the employment has become more precarious through fixed-term contracts, outsourcing, and maybe performance management, making it easier for the people to exit. But then also these labor codes in place and portion place. I feel there has been there have been cases where there have been wrongful termination of these gig workers, or I mean contractual employees also. So I think these labor codes will address them in the coming near future. Will definitely address them because I think the Jammu and Kashmir High Court in 2024 held that termination is based on an alert note alleging irregularities without hearing the contractual employee was bad in law, because they normally employed this audio alterum pattern. So he was not heard, and then suddenly he was put out of the job. So I think the labor codes, I mean the modified labor codes would address these issues also in the near
Right.
future.
So I also wanted to touch upon, like some of the countries in the West have addressed issues of employees' mental well-being, or even their, right to work-life balance. Some countries, you're not an employer is not allowed to contact an employee post their working hours. So we still are yet to see those kind of laws come in our country. But do you think that this is something that, on a judicial level, the laws need to be implemented to make sure that such rights of employees are protected, or it is something that organizations need to be responsible for?
See, there is a trend towards reclassification or intermediate statuses, as you talked of Europe or maybe other developed
Yeah.
gay. The EU platform work directives and rulings in jurisdictions. Maybe let's take for example the United Kingdom.
Hmm.
The United Kingdom normally specifies the Uber drivers as workers, and
Right.
they're often cited as workers, not as independent contractors. So as already I have reiterated, the legislative path of India is in so far is a middle course.
Hmm.
So I'll just again reiterate that special recognition and social security for these platform workers without full employee status as is there in India. While courts are taking it in a different term, they are taking it as an employee. Okay,
Right.
so we are moving towards that as employee as for full-time employees, but still that the term gig workers, the contractual employees, so that becomes a bit of,
Complicated.
yeah.
Yeah.
See, it would be
Yeah.
the organization decision whether to give that leverage or which Western country is following, because statutes are there, laws are in place. So we don't have that in our place. But
Yeah.
so, for example, we have certain. We talk about POSH Act. It's there in place, but who is following? So ultimately, unless it is followed by the organization, nothing will happen. Today, employees not in a position where they will fight for their right, because then they are fear of blacklisting or a delay. They need their employment, so they will not fight for it.
Correct.
So unless employers give something, employee are and they will be hesitant to ask for their
Hmm.
right. It's a long way to go for India to follow that. After employment, after you're working as you don't have to pick up the phone.
Yeah,
So yeah.
it is. Like you mentioned, like organizations.
I'll just add one thing before we move
Yes.
ahead.
Yeah.
As ma'am said, it's a long time, it's a long time to go before you do not pick up your phone after a year. I'll just give you two examples. We are talking of contractual employees. We are talking of gig workers. Employees. Sweden has recently introduced. Finland has already introduced 4 working days.
Co-working. Yes. Yes.
Okay, and after 6 they are free. Okay,
Correct.
so you don't have to pick up the call or receive a call or something like that.
Yeah.
They are free. So what happens in these countries? You cannot compare that with India because of the fact these countries normally, develop first and foremost, they're developed. I would not comment exactly on this, but my point of view is that we are not on the process of that development.
Hmm.
Okay, though we are a growing economy and we are a developing country and stuff, all those are good on paper and everything, but the reality is for everyone to see. So the comparison with these countries becomes quite difficult.
In fact, for a country like us, our leader is such who our PM works for 18 hours. So we have to
That,
follow that.
that's a myth, in fact.
Yeah.
It's debatable.
Right. So I think we have more or less covered all aspects. I feel like if I ask you more questions, we'll then again come back to the same discussion. But in saying that, I would like both of you to give me some concluding remarks about today's discussion, please.
Okay, I think the most important single reform, in my opinion, would be a unified cross-cutting framework for non-standard workers, covering minimum earnings, fair termination, social security, a digital safety, and a clear allocation of responsibility between platforms, clients, and intermediaries. That also includes the IC, the committees, internal committees also. uh, because today, as of today, where we stand, because these workers rely on a patchwork. POSH here, social security there, data protection somewhere elsewhere, and occasional constitutional or contract decisions, like the Ola case or the JNK 2024 case, High Court case, contractual termination rulings to plug the glaring gaps. So I think a coherent statute on dependent workers would bring the law in line with how the work is actually, how the work should be actually organized in 2026.
So, sir has quite he has covered mainly everything in nitty gritty. So I would say our labor laws are not outdated, but they are incomplete for today's work reality. There are, I mean, after COVID, things have changed drastically. Everything is digital. So to match that, there should be some amendment, which sir has already mentioned. These are things which requires to be updated. So we
Right.
are not outdated. We are just incomplete to cover those realities.
Right. All right. So with that, I would like to, conclude today's discussion. And I think one thing is clear from what both of you had to say is that the future of work is evolving faster than the laws that are
Yeah.
meant to govern it. But I'm sure, and as you both mentioned, we are working towards catching up to this evolution. And we need to make sure that gig workers are not in the gray zone and there is some proper definition for them as well. And we also have a need of clarity, clear definitions, and clear enforcement mechanisms. With that, we also need to for the organizations to be better participants in the implementation of these policies. And yes, with that, thank you so much again for joining us, both of you. It was great hearing from both of you and both your insights. And thank you so much to our audience also for joining in. Have a good evening, everyone. Thank you again.
Thank you.